If a police officer walked up to you right now and said he had reasonable suspicion to detain you, would you know if he was right? Or would you just comply and hope for the best? That compliance could cost you your freedom. I spent 43 years on the other side of that encounter. I know exactly what officers are looking for, and more importantly, I know exactly what you need to know before it happens to you. Today, we're covering reasonable suspicion, probable cause, and objective reasonableness. 3 terms, your 3 best defenses. Before we get into today's content, I want to revisit something I've addressed before, because it matters, and I want to be clear about where I stand. I have genuine respect for attorneys. I know many of them personally. They are, as a rule, sharp, highly educated professionals, and they've earned that. Passing the bar exam is not a small achievement, and the attorneys who've spent years in actual courtrooms have been battle-tested in ways most people never will be. But here's the distinction. Legal training and lived experience are fundamentally different things. Attorneys are educated on the law. I was forged by it on the street in real time in situations where the stakes were not hypothetical. I've been there. Not in a classroom, not in a deposition room. Out there where the law meets the pavement. Hey everyone, welcome back to Survive the Blue Encounter. Today, we're diving deep into one of the most important topics in criminal procedure and your constitutional rights. The difference between probable cause, PC, articulable reasonable suspicion, ARS, or just reasonable suspicion, and the objective reasonableness standard. These 3 standards come straight from the 4th Amendment, which protects us from unreasonable searches and seizures. But they're not the same. They form a ladder of police authority. The lowest rung lets cops briefly stop you to investigate. The middle lets them arrest or search. And the last one judges whether force was okay. Understanding these can literally change what happens in a traffic stop, street encounter, or even a lawsuit against police. Let's break it down step by step. Section 1. The 4th Amendment says, the right of the people to be secure against unreasonable searches and seizures shall not be violated, and no warrants shall issue but upon probable cause. Notice 2 big ideas. Everything has to be reasonable, and warrants usually need probable cause, but not every police action requires a warrant. Think traffic stops or quick street questions. That's where these standards come in. The Supreme Court created tiers to balance public safety with individual privacy. Lowest level, reasonable suspicion. Middle, probable cause, and for use of force during a seizure. Objective reasonableness. Section 2. Articulable reasonable suspicion, ARS. This is the lowest threshold, and the one most people encounter first. It comes from the 1968 Supreme Court case, Terry versus Ohio. A detective saw guys pacing suspiciously outside stores, suspected robbery, stopped them, and frisked for weapons. The court said yes, police can briefly detain you without probable cause if they have reasonable suspicion that criminal activity is afoot. Key phrase: specific and articulable facts, not just a hunch or gut feeling. The officer must point to concrete observations like furtive movements, high crime area, time of night, plus rational inferences. What can police do? Temporarily detain you, a Terry stop, usually minutes, not hours. Ask questions to confirm or dispel suspicion. If they reasonably suspect you're armed and dangerous, do a limited pat-down. Frisk for weapons only, not a full search for evidence. Example: officer sees someone at 2 a.m. in a residential area repeatedly peering into car windows. That's articulable. Could be burglary, lookout. Stop allowed. But if it's just, he looked nervous in a bad neighborhood, that's too vague, not enough. Actual example I lived. I was shift commander on midnight shift, and several of the officers in Zone 2 were conducting theft interdiction. And I overheard a young officer tell another officer to stop a vehicle. The second officer asked the reason for the stop, and the young officer stated he looked at me wrong. Of course, that stop never occurred, and that young officer learned a valuable lesson that night. There was no ARS or PC for the traffic stop. Reasonable suspicion is about a buck and a quarter shy of probable cause, way less than 50% certainty, but more than random. I want you to understand this case law, so your understanding will keep you out of trouble. Ignorance of the law is not a defense, just like voluntary intoxication is not a defense to a criminal or civil infraction. Section 3. Now we step up to the higher standard, probable cause. This is required for arrests, full searches, or getting a warrant. The Supreme Court says probable cause exists when facts and circumstances would lead a reasonable person to believe a crime has been or is being committed, and the person did it, or evidence is there. It's a fair probability, more like 50% or better practical common sense, not technical proof. From Illinois versus Gates, totality of the circumstances test, reliable info, even hearsay, if trustworthy. What can police do? Arrest you, with or without warrant in many cases. Search you incident to arrest. Get a search warrant for home, car. Search vehicle if probable cause develops during a stop. Automobile exception. Example. Officer smells marijuana strongly from your car. Sees paraphernalia in plain view. Probable cause for search and arrest. Big difference from reasonable suspicion. Terry stop might lead to probable cause. For example, when you admit something during questioning, then they can arrest. But you can't jump straight to arrest on just suspicion. Section 4. Objective reasonableness. Standard. This one is different. It's mainly for use of force cases from Graham versus Connor, 1989. When police use force during a seizure, arrest, stop, etc., courts ask, was the force objectively reasonable under the Fourth Amendment? Not what was the officer thinking. Subjective intent doesn't matter. Instead, what would a reasonable officer on the scene think without 20/20 hindsight? Factors from Graham. Severity of the crime. Does the suspect pose an immediate threat to officers/others? Is the suspect resisting or fleeing? It's judged from the perspective of a reasonable officer facing split-second decisions. Example. Suspect reaches for waistband during high-risk stop. If reasonable officer thinks it's a gun, force, even deadly, might be justified. But if it was just a phone and no other threat, maybe not. This standard applies whether the encounter started with suspicion or probable cause. It's about how force is used once the seizure happens. Section 5. Quick comparison and real-world scenarios. Quick ladder. Reasonable suspicion leads to brief stop plus possible frisk, Terry stop. Probable cause leads to arrest plus full search. Objective reasonableness leads to was the force okay during any seizure? Scenario. Cop sees erratic driving leads to reasonable suspicion for traffic stop. Smells alcohol leads to probable cause for DUI arrest. Driver fights back aggressively leads to objective reasonableness. Judges if taser or takedown was okay. These protect against abuse, but give police tools to act quickly. Conclusion. So there you have it. Probable cause, reasonable suspicion, and objective reasonableness. The three pillars controlling police power under the Fourth Amendment. Knowing them empowers you during encounters and helps understand court decisions. If this helped, drop a like. Subscribe for more legal breakdowns and comment, which standard do you think is most controversial? Thanks for watching. Stay informed by liking, comment, and subscribing. Y'all stay safe. See you next time.